I've just broadcast this. I just turned the webinar on, just so you know.
Oh, okay.
So attendees can now actually come in. They probably could come in on a box, but just so you know, we're on.
We're live.
You think I should wait, I guess, for a couple minutes?
Yeah. Will you get an indicator when people come on?
We already have two.
Me and Javier.
That's right.
And it's Allison. Allison's here. Allison Richards. Mm. Mm. Okay. Right.
Feels like a good day to stay at home.
Yeah, it's pouring.
It is. Yeah, so we got, so we'll wait for, maybe we'll wait for like first couple minutes. We should wait for a little bit.
Okay. But are we live right now?
We are.
Say hello to the people that are on.
Yes, they're still kind of filtering in though. So why don't we kind of, okay. Yeah. Well, welcome the attendees that have already come on. We're going to wait a couple more minutes to start the webinar. We'll probably start about 11:35 and get it going there as the attendees start to come on. And thank you all for joining. Okay.
I have a question. The materials, we were supposed to have a PDF available. I don't know if there's a link to it in the invite or there's a page on the association's website to download that PDF.
I think Chris put those in the chat box.
And then those are links to that are newer, separate from the materials. That there's a PDF with, I don't know, about 90 pages of stuff.
Okay.
So, Chris, do you know if we have a link to that, or was it on the
Well,
invite?
we can send it out. I know Michelle sent some information out initially, but we can send it out. invite to send it out to just, I guess, contact us, and we can send it out that way for whoever wants the information.
Great.
Okay, so I want to get started. I want to welcome everybody that has come to the webinar. I'm Chris Aiken, the chair of the Downtown Business Association, and on behalf of the association, we'd like to start doing some webinars to help our business public. Anyways, I'm Chris Aiken. I'm from a law firm called Aiken & Cohn. We specialize in personal injury litigation. With us today as a moderator as well is Vicki Wilson. That's Vicki there. She's the owner of Tax Pros Plus with a lifelong passion for small business through networking, communication, and collaboration. Just a little bit about the format today. What we're going to do is, in the Zoom meeting, you'll see there's a chat box, and already it's populated with some very helpful links that apply to the subject we're talking about today. We certainly encourage any questions through the chat box, and we will certainly want to answer any questions that anyone has here for Javier. So please send questions that you have. But today what we're going to do is the topic is multifaceted, and I want to basically the topic will be stay-at-home executive order and 3320, the Family First Coronavirus Response Act of 2020, and the Coronavirus Aid Relief Economy Security Act of 2020, also known as the CARES Act. And we are very pleased to have Javier Carbone here that's going to talk about this subject. He is an employment law litigator, a labor relations consultant, and workplace investigator. He can be reached through his website, rcpc.com. And Javier, I want to really thank you for coming to talk to us about this very important topic today. And with that, I'd like to turn over to you, Javier. Thank you.
Well, thank you, Chris, for having me. Thank you, Vicki, for having me. I want to begin by saying that we have some written materials that were intended to be in the invite on a PDF format for you to download. And the materials have a copy of the governor's order, has a copy of some relevant information on the law, federal law, that creates an emergency paid sick leave, and some summary created by the US Senate on the CARES Act, which is the law that provides the financial stimulus loans and other things. So we're going to talk about all of that from the employer's perspective, but I want to go back to what Chris mentioned on the chat box. You should also have a couple of links to websites that are useful for employers to have, to read, and to maybe share with some employees. There is one from the Center of Disease Controls and Prevention, the CDC. There is one that is intended for employers only from a California office that is known as the Labor and Workforce Development Agency, the LWDA, the Employment Division of the Department of Labor in California, the EDD, that we all are familiar with. And I believe that there's a COVID-19 California page and the County of Orange page, and that should give you more information that you care to know, but it's good to know what the official information is out there, because unfortunately there is a lot of misinformation concerning COVID-19, and part of the idea of today's presentation is just to give some clarity or to find a source for the most common questions. So let me just jump right to it and begin with the stay-at-home order issued by the governor. And as you may remember, several counties issued orders asking people to be safer at home, like the County of LA COSET, and the County of Orange asked people to stay at home, but 2 days later, the governor issued a statewide mandate saying that people should stay at home unless they are part of the critical infrastructure. And at first, it was hard to find out who was part of the critical infrastructure and who was authorized to continue working, But on March 22nd, 2020, there is a memorandum which defines the 16 sectors that are critical for the United States to continue in operation. And there is an actual list of jobs of people who are essential critical workers. And the basic rule is that we are asked to stay at home unless we are part of the essential critical infrastructure. And if we are part of the essential critical infrastructure and we are on this list of the March 22nd memorandum, we have a couple of choices. So the first choice that employers typically have is to close their business because we have been asked to stay at home. There's not enough business, so it makes sense to close the business and wait until the governor changes the order and we can go back to business as normal as it can be. That's the first option. The second option is to allow people to work from home. And it has become very popular for most companies to allow people to work from home if they can. Technology now allows for that. The magic of the internet is allowing things like what we're doing right now to do it from home. But there are a couple of concerns that I want to bring up, that if you allow your workers to work from home, you should be mindful that under the California Labor Code, any expense of an employee that is for the benefit of the employer has to be reimbursed to the employee. And I can foresee some employees making a claim for a fraction of their cost of the internet at home, maybe a fraction of the cost of the use of a mobile phone or cell phone at home. And some people have even asked for the cost of having a chair, table, laptop, printer, and whatnot. Be mindful that if those tools are used at home for the benefit of the employer, the argument could be made that the employer has an obligation to reimburse the employee for those expenses. Also, it is important to remember that for those hourly employees, people who are paid by the hour, their labor rights are with them at home. And the Department of Labor has issued some guidance suggesting that as employers, we should remind employees that they have the right to take a rest break, 10 minutes rest break, and they have to take an unpaid half an hour meal period during their regular workday. So the fact that people are working at home, we should remind them that they should keep the same or similar number of hours, and that within the regular workday, they should take rest breaks and enjoy meal periods. Now, if a business is not working from home, if a business is not closed and they're part of the critical infrastructure, they may decide to continue operations. If a business decides to continue operations, there are a couple of subjects that we have to be mindful as well. For example, and this came as a question, one of the duties that the employers have in California is to provide a safe workplace. And if we are asking people to leave their home, when the governor is asking people to stay at home, are we asking them to put themselves at risk? And the answer comes from some guidance from OSHA, which says that as long as an employer follows the guidelines of the CDC to take preventive measures to avoid risk of being infested with COVID-19, then the employer is okay to ask people to work and continue working as part of the critical infrastructure if the safety guidelines are followed. That's why there's a link to the latest CDC guidelines, and be mindful that this change constantly. For example, yesterday, they changed the guidelines for emergency workers, and there are new guidelines for emergency workers to continue working, believe it or not, even if they're infected. It's on the website. And also, I think it was a good idea. It'll be a good idea to give a notice to employees to let them know that the decision has been made to continue operations and to point them to the preventive measures and to other resources so they can get information. Because when you ask people to continue working, and this happened last week or a couple of weeks ago, but it may happen now that some businesses are going to reopen, it's good to give information to the employees so they can then have less questions and hopefully go back to work with the information that they need. On a related question is, can an employee refuse to come to work? If I am part of the critical infrastructure as an employer, Is it possible for an employee to say that he or she is going to avoid the risk of getting infected by not going to work? And the answer is no. In general terms, an employee cannot refuse to return to work because OSHA says, and it's on the OSHA website, that if the employer is following the CDC guidelines and avoids the risk, there is no imminent risk to the health of the employee. And for that reason, the employee should not refuse to come to work. And in California, we have an employment at will general rule that applies. So if an employee refuses to come, the argument could be made that the person is essentially quitting because they are willing and able and should be willing and able to return to work. And by refusing, they're essentially quitting. Sounds rough, but the law seems to be on the side that as long as the employer is not asking the employee to intentionally put themselves at risk, imminent risk, by following the CDC guidelines, then the employee must come back to work. Now, a couple of follow-up things. This is California, and we have more protective laws than the rest of the nation. And we should be mindful of a couple of things. First, under the California law, which protects against discrimination, it includes medical conditions. You see, a virus like this is not a disability because it will go away one way or the other. But under California, medical conditions are included, which means that an employer in California may be required to provide a reasonable accommodation to somebody who has a medical condition, such as the virus. So this is not a clear-cut, black and white answer. There's some gray area on whether an accommodation is necessary for somebody who's infected with the virus, but in the absence of an infection, an employer may ask an employee to return to work. Lastly, on this subject, we have to be mindful that the National Labor Relations Act, which is a federal law that allows for employees to band together and form a union, but even without a union, employees can get together and seek mutual protection. So if the employees get together and they, in some way, in order to protect themselves, engage in any activity to criticize the employer, that's protected. In a way, that's why we have seen on the news so many group of employees up and about talking about the concerns that they have with their workplaces that are continuing to work during this national emergency. Now, Chris, what I suggest is before we move to the Families First Coronavirus Response Act, maybe we can take a couple of questions on the stay-at-home order of the governor and then switch and change the subject to the other one. So any questions?
What's the, how would you characterize the difference between a furlough and a layoff?
Right, that's a good question. So I had planned to talk about furloughs and terminations on the next subject, which deals with the Emergency Paid Sick Leave Act. But let me just answer the question briefly. There's no difference. That's a distinction without a difference. It doesn't make a difference. It's the same word. It essentially have the same meaning. Let's just be honest. The question is whether the employment relationship has ended, right? And there are two parts to that. First part is, do we intend to bring the person back? And that's the real important question. If we intend to bring the person back, then it's not a termination, it's not a firing. We can call it furlough, we can call it layoff, we can call it whatever we want, pause, freeze, anything, because we have, as the employer, the intention of bringing the people back. Separate from that, however, the California Labor Code has some obligations on how and when people are supposed to be paid. So by operation of the Labor Code, it may be necessary for employers to pay all the wages due to an employee and give them a paycheck. Now, tragically, it's known as a final paycheck under the Labor Code, but really it's not because we have ended the employment relationship, it's just because we have a duty to pay. So you can furlough somebody, or you can put them on a pause, or you can lay them off, and maybe you have to pay, but that doesn't mean that you don't intend to bring them back. So my advice, and I'm going to talk to this now, but to answer the question, we should let people know that we have the intention of bringing them back. The flip side of that coin is that we should let people know if we do not have the intention of bringing them back. I know of some companies that have already decided to let people know that they're not coming back and they have suggested for people to look for a job elsewhere. Any
Well,
other questions on the stay at home?
So one question here. My business remains open. You know, what are my obligations to the employees? And specifically, let's talk about liability. I mean, you know, there's also, what can liability exposure can a business expect based around what's happening here, Javier?
Yes, that's a really good question. So from the perspective of the employment law relationship, if we are part of the critical infrastructure and we are authorized to continue operations, and because we have a duty to provide a safe workplace, as long as the employer follows the latest CDC guidelines, the employer is not at risk of being liable to the employee for putting the employee at risk. Because if the employee, unfortunately, gets sick, that's what workers' comp is there for. So if somebody at work gets sick, they should be compensated by workers' comp, and that is the exclusive remedy that the employee has against the employer. They are unable to file a lawsuit against the employer because workers' comp covers that risk. Having said that, I said that there are a couple of steps. First, we have to provide some safety equipment. We have to follow the guidelines. We have to make sure that we try to avoid the employees getting hurt or sick. But unless you intentionally ask somebody not to wear protective equipment, unless you take some measures like the ones we have seen, like shields and distancing markers and other tools like gloves and of course masks and other protective gear, unless we ask somebody just to disregard all of that, there's no liability because it's covered by workers' comp. Make sense?
Yes. Thank you. Thank you, Javier.
Chris, I did want to interject one thing on the tax side. Javier had mentioned these expenses at home, right? And that's a really great point from my business, right? That one of the things that happened when they passed the Tax Law Act of 2017 is you can no longer deduct unreimbursed employee expenses. So if you're working from home and you think, oh, I'm going to go buy myself this really awesome, you know, ergonomic chair and this new desk and all this kind of stuff, you can no longer write that off on your taxes. So just know that, you know, before you go spend a bunch of money.
All right, thank you. So Javier, can you kind of, I guess, now get to, I guess, the second part, the Family First FFCRA. Can you kind of tell us a little more about that?
Absolutely. You know, in employment law, it's all about the lingo, right? So the FFCRA, the Families First Coronavirus Response Act, this is the law, the first law that was approved now 3 weeks ago. And what the FFCRA does is a couple of things. First, it provides for emergency paid sick leave to some employees. And the emergency paid sick leave is available to some employees. And when I say some employees, that means of employers that have less than 500 employees, they're entitled to get emergency paid sick leave. Now, the second part of the law is that employers who have more than 50 employees, which are required by federal law to provide Family and Medical Leave Act and under California CFRA, also Family and Medical Leave Act, those employers have expanded FMLA CFRA leaves. But most people, honestly, most employers have less than 50 employees. So the only thing that is available for employees of less than 50 is the emergency paid sick leave. And about that, there's a couple of things that I want to share. First is that the law requires all employers to make a notice and give a posting and to put up a poster that is on the Department of Labor's website, the U.S. Department of Labor's website. The first day, it was only in English. Now they did a Spanish version, and last time I checked there, it is in 6 languages, but you're supposed to put that up. In the materials and the PDF that we have shared, there's the English version of that poster, and the interim regulations say that by sending those posters by electronic means, the employer complies with the obligation of the posting. So my unsolicited advice is that take a copy of it in the languages of your employees, and send it to them by electronic means so you can check that box and make sure that you have complied with putting up the poster. Because the idea of the politicians is that everybody knows that they have emergency paid sick leave. Now, on the one hand, the politicians are telling people that this emergency paid sick leave is available to them. On the other hand, the US Department of Labor has issued a temporary guidelines and some Q&As that is on their website, but there are some rules now that say a couple of things that as employers, we should know. The first one is the timing of the leave. The Q&A say that the leave applies to any leave taken from the date the law became effective, which is April 1st, until December 31st. Let me say that again. This emergency paid sick leave only applies to leave that is taken between April 1st and December 31st, which means that in California, for example, those first 2 weeks when people were at home, because the governor said so, do not qualify for this emergency paid sick leave because they happened before the law became effective. So any leave that happened before April 1st is not part of this emergency paid sick leave. And also, if the employer is closed, the employees are not entitled to emergency paid sick leave. If there's not enough work, even if open, if an employer doesn't have enough work for the employee cannot, let me say it again, they cannot get emergency paid sick leave. And that's under the temporary rules of April 6, 2020. And that means that most people who thought they were going to get it, they may not get it because of the definition of the timing and because of the definition of who has enough work to be able to work or not. And finally, and this is the point that I wanted to bring about the furloughs and the termination, is that because the law said that the leave only applies to anything that happened after April 1st, on March 31st, a group of employers made the decision to either lay off, furlough, or terminate their employees before this law became effective. Now, any furlough or layoff that happened before April 1st, or any furlough or layoff that happens now after April 1st will have the same effect, which is that the employee is no longer eligible for this emergency paid sick leave. And a couple of things, in addition to what I already said about furloughs and layoff, which is the intention of letting the employee know the intention of the employer to bring them back or not. The Labor Code requires, Labor Code Section 201 requires for employees to receive all their wages within 10 days or the next payroll period. Let me say it again. If you laid somebody off, then within 10 days or the next pay period, whichever is first, the employee has to receive all the wages due. That's known as the last paycheck, which includes any hours worked, maybe none, 0, but also any vacation pay, because vacation in California are wages. Paid time off is also considered wages under California law. So they're supposed to be paid out or paid off within 10 days of the layoff. And this is going to trigger the preparation of that final paycheck, but that doesn't necessarily mean that we're not going to bring the employee back. So my unsolicited advice number 2, if you laid somebody off, let them know whether you're going to bring them back or not. And that will help clarify if they qualify for the emergency paid sick leave or not. And it's also going to help release the tension of whether the people are going to have a job after this national emergency ends or not, or if they should start looking for a job right away. A couple of follow-up comments on the FFCRA. The first is that the law is intended to provide emergency paid sick leave of up to 80 hours of pay for people who have been infected, who are taking care of somebody who's infected, who have been ordered to quarantine, and for people who have children that are unable to go to class because their schools are closed. Now, the people who are infected, taking care of somebody who's infected, or who are quarantined will get 100% of their wages up to 80 hours. But the law says that people who are at home because the children have no school only get 2/3 of pay of the regular rate of pay for those 80 hours. So it's important to know that it's not 100%. It may be less in the case of school children. In California, all the schools are closed. So it applies to most people who qualify under those conditions of the kids not being in school. So that's what the law was intended to do, with the caveat or knowing that it only applies for that leave that happened after April 1st, and knowing that if the person is laid off or if there's not enough work, the employee is not going to get any of that. Having said that, I think it's important to know that this emergency paid sick leave is under a new federal law, and that means that that is completely unrelated to anything that is under California law. And what does that mean? Well, under California law, we already had a paid sick leave act, which gave up to 24 hours of paid sick leave to employees if they were sick. So that's separate from this emergency paid sick leave. And in order to get California paid sick leave, of course, the employee has to be sick or seeking medical treatment, and any other PTO or any other benefit or leave that the employer gives is separate from the FFCRA leave. Now, I suggest that we may take a couple of questions now about the FFCRA, if there's any. Chris?
Just a couple clarifications. One question would be, so as far as a business person's obligations as relates to the final paycheck, can you go over that again, exactly what their obligations are there?
Yes. So we're talking about if the employer makes the decision to lay off or furlough an employee. The furlough means that the employee is going to come back at some point, and we're going to let the employee know that we have the intention of bringing him or her back to the position that they had, right? So that's what triggers the next obligation, because first is that we're letting the employee know what our intention is, that they're not going to work for the time being. But California has a section of the labor code that says that when an employee is furloughed and the employee is not given a specific date of return, let me say it again. If an employee is furloughed and the employee is not given a specific date of return, and right now no one can do that, no one can give a specific date of return, then within 10 days or the next pay period, the employer has to pay all the wages due to the employee. So within 10 days or the next pay period, the employer has to coordinate for the preparation of what is known as a final paycheck, which is any wages due, any commission, any PTO, any vacation, anything that the employer owes the employee has to be paid out on that date. And that's an obligation that is an interaction of the laws, but we should be aware of it because we want to be able to check that box if somebody comes and asks from the DLSC or the Labor Commissioner's office. Of course, not now, but later, right?
Right. So the other question, Javier, is I know you mentioned a little bit earlier about this new labor poster. I mean, I know it's going to be in your materials, and we appreciate you sharing that. The question is, if the business is closed, what is the full obligation to share such poster on a closed business to current or recent employees? How would you characterize that?
Yeah, that's a really good question. It doesn't make any sense to ask people who have a business closed to put up a poster, right? It doesn't make any sense. But the reality is that the law says that we have to put up the poster, and the regulations say that by sharing the poster by electronic means, the employer complies with the obligation of putting up the poster. So that tells me, and this is just my interpretation, that the US government, and specifically the US Department of Labor, is assuming that we have a way to communicate by electronic means with our employees. And quite frankly, they may be onto something, because if we don't have an email from our employees, we may have a text that with smartphones that most people have, maybe a link to the poster should be enough. So it will be a good idea and good practice to send them by email, by text, or by any means necessary. We may even use the good old USPS to send them a copy of the poster. But it is pretty, they don't expand too much on the explanation, but the regulations do say that by doing it by electronic means or by mail, the employer complies. So the best practice is just to go ahead and send it to the employees so we can check that box. Or put it up when they come back, but by then it will be too late, I think.
Perfect.
Yeah, that's great.
Javier, can you tell us now while we turn to the CARES Act, and there's been a lot of talk in the media about the CARES Act, how it's working, et cetera. Can you kind of give us a rundown of the CARES Act and its benefit to the employees and the benefits to employers?
Yes, so the CARES Act, I just want to talk a little bit about those sections that deal with the relationship at work. Most of the CARES Act, of course, have to do with the financial help and the loan programs, but for employees, the CARES Act have two things that directly affect the employees. The first is the temporary expanded unemployment insurance benefits. And what happens is that employees who qualify for unemployment, and I have to take a pause and talk about California unemployment. Under California law, people who are unable to work for no fault of their own, they're unemployed. But the governor issued an order saying that if you are unable to work during this national emergency, essentially you're going to get unemployment. It doesn't matter if you're an independent contractor. It doesn't matter if you are a casual employee. It doesn't matter if you are self-employed. The state of California has essentially said that during this national emergency, anybody who's unable to work the same number of hours, they're going to get unemployment from Sacramento, right? So the unemployment benefits under California law, they're in place, and that's already in play, and people have already asked for unemployment, or they will. Separate from that, the US government has said that anybody who's receiving benefits from the unemployment insurance of their states are going to get from the US government an additional $600 per week unemployment benefit. And that means that whatever California gives, the US government is going to give $600 more per week for anybody who's under California unemployment. Make sense?
Yes.
This means that some people may get up to $450 from California in unemployment benefits per week, and separate from that, they're going to get $600 from Washington, D.C. And that means that people who make about $25, they're better off not working during the next 12 weeks because they're going to get more from the state and the federal government than if they were working. So for people who make that less than $25 an hour, it's kind of an incentive not to worry, because their budget should be covered by this unemployment plus the federal unemployment. And for people who make more than 25 per hour, of course, it's not going to be enough, but at least there's something to cover those basic expenses. And that's the theory that the policy behind the CARES Act unemployment portion deals with. The second part that helps employees under the CARES Act is the stimulus payment of up to $1,200 for people who pay taxes. So taxpayers should get sometime soon up to $1,200 directly paid to people, taxpayers, I should say. So that's what the CARES Act has for employees. For employers, there are essentially two sections that help employers that are small employers. And one is the Economic Injury Disaster Loan Program. And under the Economic Injury Disaster Loan Program, employers are able to get a loan. And the important portion of that loan is that upon application, immediately people were supposed to get $10,000 advance. I say they were supposed to because this began last week and they were supposed to be immediate, but here we are on Thursday and I haven't heard of anyone who has received it. So the definition of immediate under the law is up in the air, but as immediate as the treasurer will make it happen, there will be a cash advance, but this is a loan that has to be repaid. And there was some wrangling on interest. First, they said up to 4% interest, and the last guidance from Treasury is essentially says it's going to be at 1%. And separate from that, there's the now famous Paycheck Protection Program, or affectionately called the PPP, which is, of course, another loan under the old SBA rules, which makes it complicated. But if the employer uses that loan under the PPP for purposes of keeping and maintaining payroll for the next 8 weeks, then that portion of the loan is going to be forgiven. That means that doesn't have to be paid back to Washington, D.C. That's the theory. Again, the PPP, as most people, I'm sure, have heard, it's also developing, and it's, there's some friction in the application process. But that's the theory, that there's some money set aside for that, and they're talking now of making the pot for that section even larger than the original amount of money. So those are the two part of the aid package that are under the CARES Act that applies to the employment relationship. The employers should get some help in paying payroll, and employees should get some help in keeping their expenses at home during this national emergency. Now, I'm not a banker, but I will entertain some questions on the PPP.
I think, and maybe Vicki, I can include you on this question as well, is what are some of the kind of war stories you've heard about the PPP program and this application process in the last week? I know you guys involved a lot of different businesses. Do you have any thought process of what you heard from others as relates to this PPP program and the application process? Javier or Vicki, I'll open that up for you guys.
Yeah, initially, because these are funded, if you will, through lender/banking relationships. These will not come directly from the SBA. They're coming to you through your local lender. So all the major banks around here had a process where you could go on and apply to get an application. So that all happened last Friday. And then Wells Fargo wasn't ready on Friday, so they opened theirs up on Saturday, then immediately closed it. And they're not taking any more applications. Bank of America, we do have one business member of the DBA that was allowed to upload the information that they wanted from her. She said it took her about 2.5 hours to upload that information for them. Chase's site is crashing when you're getting the response to come back on. So hasn't worked out too well so far for most people that I know, but I do have a friend in Colorado who said just stay patient, stay persistent. She did actually get the $10,000 advance. So she said, don't lose hope. Just, keep plugging away as much as you can, but it's all online. You cannot go to your branch and beat on your manager there. There's nothing they can do. They're doing everything through this online process. But as Javier mentioned, if they add more money to it, then hopefully, they can hire some more people to process the loans. I think that's probably the bigger trip hazard right now, is there's not enough people working to process the flood of applications that came in.
Now, let me say something. I want to add that in your materials, you're going to have a copy of the suggested application from Treasury. We should answer all the questions your bank may have. There's a summary of the PPP, and there's some guidance on the PPP, but I also included the interim final rule on PPP because it reads like soccer. If you know football, this is like soccer. It is convoluted and hard to follow, but it is important to me that you have the interim final rule so you can read it for yourself, because there's a lot of misinformation as to how much can be borrowed depending on how much money you spent on a specific period of time that happened last year, right? So you have to go to last year, and based on how much money you spend on a specific period of time, you have to then use a formula to borrow now and spend it in the next 8 weeks. So it's there, it's in writing, it's in English, but I understand it. So read it, ask questions to your local friendly neighborhood financial advisor or tax person, because it is important to go to the bank and say, look, here's the rule, help me understand, because I've heard horror stories, right, Vicki?
Yeah, everybody's just scrambling and we're just running in circles. I don't know if he's getting anywhere yet, but definitely if they're going to reopen it up for businesses to apply, make sure you start getting your ducks in a row now. So to Javier's point, you're going to need to know what was your total amount of payroll for last year. You're going to want to know, well, how much did you pay for rent? How much did you pay for utilities? How much, basically your profit and loss. So if you've just been collecting receipts all of 2019 and stuck them in a shoebox and you haven't done your books yet, you definitely want to get on that right away because you're going to need it. Also,
and Vicky, if I may, February 15 to June 30 is the lookout period for the PPP, the look back. I think it's February 15 to June 30. So you see, it's weird.
Yeah, there was that, and then they're just saying take it for your whole year or whatever. But one of the things I did want to say regarding all these different bank processes, it also seems as though each lender has separate criteria for the documents that they want. So for instance, Chase wants a copy of your 2019 business and personal tax returns. So if you are someone who normally does an extension or you're not ready, you better run out and get your 19 taxes done if you're going to try to do this program through Chase.
Now it's again, I'm not a banker, I'm just an employment guy, but the Treasury has said that no underwriting is required for these loans, and banks are underwriting these loans. They're treating these loans like any other loan. So there's some friction between what the Treasury wants and what the banks seem to want. And some banks have said that if you're not a customer of their bank, don't even bother.
Right.
They don't want to talk to you.
Yeah.
So talk to your friendly banker, neighborhood banker.
I'll tell you, there is one of our attendees, it's more of a comment, but I do want to bring the comment up. And if you maybe just have any comments, if you can. The concern is basically that seems like the larger corporations have used the funds up associated with the program, that the small mom and pop businesses are being turned down. That's a concern of one of our attendees. Do you guys have any feelings on that as far as, I don't know where it's words of encouragement or whatever, you can maybe comment on that.
Well,
heard anything in that.
Javier and I talked about this a little bit yesterday, and it's kind of like, I mean, if you're truly a small business, when these loans are saying, your payroll up to $10 million, it's like, is that a small business? I don't know about you, but my payroll, is never gonna get to that. So I don't know if that truly is something that's happening. I think everybody just went, oh my gosh, if there's an opportunity for me to do something, let's just apply. And again, if they're gonna gross out, provide more funds for this moving forward, I think the number on the table is at 500 billion or something like that. So just keep logging on and just keep trying. There is a link on sba.gov where you can search for other lenders. The recommendation was to go with the current banking relationship that you have. But in the case of Wells Fargo, if they've shut the door, then you're going to have to go look somewhere else. But make sure that that's been vetted through sba.gov so that you're not going to some phony baloney, somebody set up a website and stealing all your information type place. So, I'm hopeful we'll have some updates maybe next week from some people who have gotten through the process and see how long it takes once you can get there.
Right. I agree personally with the concern of the person who put it up. Having said that, I am hopeful because the Treasury has been pretty clear that they want the money to be with the small businesses. Number one. Number two, they have said that the loans are open up to December 31st, 2020. It's like, wait a minute, I need the money now, not in December, right? But at least they're saying, oh, this is, for whatever reason, they're thinking this is more like long-term financing. And because everybody rushed the banks last Friday, the politicians are already talking about how much money they're going to put on the pot. So the question is not if, the question is how much more. And some politicians are saying that it's going to be a lot more to keep the economy going. Hopefully, they'll agree on that quick to ease the tensions. But from the Treasury perspective, the money will be there, especially on the forgivable part of it, because the idea is for people to continue to receive their payroll for the next weeks. So I'm hopeful that more money is going to come. They're going to just print it and it's going to be there. And this is my personal comment, and I'm just gonna say it, they should do away with this SBA stuff and just say, look, if you file corporate taxes, we're gonna give you a loan based on how much money you made. And just make it simple. Make it simple on your ability to spend, because you shouldn't spend more than what you made, right?
Right.
So it should be very simple, like a one-page thing. But I'm not elected, so, and my campaign doesn't begin today.
There are a couple other questions. One would be, and this is something that Javier, you and I have talked about quite a bit, the independent contractor. How does the independent contractor and the businesses that have independent contractors factor in all this as far as how they relate to these benefits, et cetera, and what advice would you give as far as independent contractor and the employers that use them?
Right. So I have many thoughts on independent contractors, but let's see if we can follow, what we just talked about. So the independent contractor relationship from the point of view of the CARES Act, if somebody is an independent contractor, the Treasury has said that they may qualify for their own PPP loan beginning tomorrow. So everybody who's been waiting for a week to file their applications are usually independent contractors who are going to go and say, hey, I need to keep a payroll, mine, and they're going to apply for a PPP. Well, technically, they're allowed to. I don't know what that looks like, right?
Right.
But the guidance is that independent contractors will qualify for PPP. Taking a step back to the unemployment benefit, the governor of California has said that independent contractors who are unable to get hours or be paid will also qualify for unemployment in California. They didn't before, but they will during this national emergency. So independent contractors should also get unemployment benefits. And if they get California unemployment, they'll get the $600 federal unemployment plus, I'm gonna call it. And talking about now about the emergency paid sick leave, if you're not an employee, you don't qualify for that. You see, independent contractors don't qualify for employee benefits because they're not employees. Which then takes me to the last point, which is in California, because there was a law that was approved last year and it became effective at the beginning of actually a long time ago, but the famous AB 5, for the last year and a half, there has been a court ruling that essentially says that it's virtually impossible to have an independent contractor in California. Let me say that again. If you hire somebody who is in any way related to your business and what you do, that person cannot be an independent contractor. In order for a person to truly be an independent contractor in California, it has to be somebody in a business different from your business. And the analogy that I like to use is attorneys, right? I am in the law business. Most of you are not in the law business. So if you hire me or Chris to do attorney work, that's a truly independent because we don't do what you do. But if Chris hires me as an attorney to do independent contractor work, that is not going to pass the test because we're both attorneys. Make sense? Yeah. So be mindful and be careful because the state of California has taken a very strong position that the independent contractor relationship is tax evasion. And they're going to come after employers for the workers' comp. They're going to come after the employers for the unemployment. They're going to come after the employers for the withholdings. And this has a name. And let's be honest, it's called Uber. This is a war between Uber and Sacramento. And everybody else is just in the crossfire because the independent relationship that we used to have is gone. The control factors are gone. Now, essentially, the question is, are you all in a different business, right? So, Chris, I hope that helps to clarify what the status of the independent contractor relationship is in California, what independent contractors may get under unemployment and under the CARES Act.
It does, thank you. So before we close up the webinar, maybe if I could invite you to, I guess, share any other agencies that you know about, information. I know for instance, on this chat box, there's a bunch of helpful links, maybe some agencies where you can find more information. And then, any final comments, Javier or Vicky, that you would have for our group here.
Right, so let me just begin by saying that on that chat box, there's some links to websites that are useful. And the first one is the CDC. And the CDC website has some specific guidance on steps and preventive measures to take at work. They have some posters, they have some guidelines, they have some good resources. And I think that employers that are going to remain open should go there and see if it changes, because like I said, they just added another page yesterday. The second is the LWDA, which is a California agency that has like a group of useful information in one page for employers, for employees. And the purpose of the LWDA is to try to answer most of the questions. The LWDA is one of those agencies that they have a budget but nothing to do. So that's why they have a pretty website. Again, my opinion. But it is useful and it's pretty good. It's better than the EDDs. So the LWDA website is the second link. The third link is the EDD. Now the EDD, the Employment Development Department of the California government, what they want essentially is to manage the unemployment insurance, right? But they also manage the temporary disability insurance, and they handle other types of insurance. So if you are sick and you actually have the virus, you may qualify to receive some temporary disability benefits. And that's under the EDD page. And it's good to point the employees to that resource for them to find out more information about unemployment and disability benefits. And then we also have a page from the state of California with COVID-19 information. And I think we're sharing the OC, the Orange County, which is pretty simple. It's more like a box score, but it's good to know, just to keep track how many cases in a county. For example, as you may know, it went from 54 to 50 to 91. That's not good. In San Clemente, it has remained steady, and it has it by city. So it's good information to know that at least in San Clemente, it's steady, but in the county, it's up and down, right? My final thought on all of this is that the employment relationship is going to be affected no matter what, because even when we are open again, many questions are going to come up, like, can I continue to work from home, right? Do I have to show up, right? What about pay? Now, there's been some employers that have increased pay temporarily. Well, good luck with taking that back, right? So the way we work and the way we deal with each other at work may change, because even if everything goes back to quote unquote normal, the flow of business may change. And what I mean by that, maybe we'll be doing more things online. Maybe the customers will approach us in different ways. Maybe we'll get more things delivered. I don't know, but it's important to be mindful of what the labor laws are, because the labor laws are always behind the times. Let me say that again. The labor laws are always behind the times. Sometimes businesses are doing things that the labor law doesn't consider, and by the time there's an amendment, then businesses are way ahead of the legislators. Some of the laws that we have on the books go back to the beginning of last century, and they haven't changed in 70, 80 years. Some of the most frequent laws, like the wage orders, have 20, 25 years. You see, labor law is very slow. So the more you know about employment law, the less claims you're gonna have, and the less claims you have, the more profit you have to give it to Vicky, right?
That's right.
To pay taxes. So Vicky, any thoughts?
Yeah, I just, my thought is just really to say thank you, Javier. This is, as a business that's still open, this has been tremendously helpful to give me some information that I was not aware of. So thank you so much for that. I really appreciate it. And then Chris, to your point of, if there's any other hope, around some of these, the PPP program and stuff like that, at the very least, if you are still paying payroll, you're a business that's open and paying payroll, and you don't get any satisfaction through going through these loan processes, there still are some avenues available to you through deferment of payroll taxes for a year. And also there's some payroll tax credits that you can apply for. You cannot use them in conjunction with either of these loans. So if the door gets shut on you here, that other piece is available to you as well. So, but just thank you guys for putting this on, and I really look forward to getting some more information from, keep the series going. So
no, we will. I mean, and we also invite our membership, if any ideas that they want to have talks about, we'd like to certainly answer and help our businesses here. I really want to do a real thank you, Javier, for you and for your talk today. Thank you, Vicky, as well, for all your great comments here. Just as a sideline, if you have any questions, feel free to contact Javier. It's rcpc.com. And if you have any topics or questions that you have for the DBA, feel free to contact us at info@scdba.org for any topics or questions that you have, and we'll make sure we get them answered. Any materials that you want, we'll make sure we get them to you so we can help you there. So thank you all for attending, and thank you again to our panelists. We really appreciate it.
thank you, Chris.
Thanks, you guys.